Do we have too much government?
We need to put people ahead of corporate profits.
This system is so lopsided. This threat is a real threat to democracy.
And I think that's really important. That's something we haven't been doing in this country for a long time.
Where do you start? What do you do? How do you do it?
Access to Democracy is sponsored by Thomson Reuters, providing legal professionals with the intelligence, technology, and human expertise they need to find trusted answers. Products include Westlaw, Practical Law, and Firm Central legal practice management software for small law firms. Thomson Reuters, the answer company. Online at thomsonreuters.com. Access to Democracy is made possible in part by a donation from Firefly Credit Union. Firefly is the new name of U.S. Federal Credit Union, which has proudly served the financial needs of the Greater Twin Cities community since 1925. At Firefly, we guide our members forward and give them the power to chase dreams by delivering the financial solutions they need to get ahead. From checking accounts to mortgages, we'll light the way. We are Firefly Credit Union, and this is Life Illuminated. And Dr. Charles Crutchfield of award-winning Crutchfield Dermatology in Eagan, acknowledged as one of the nation's best physicians. A Minnesota native who trained at the Mayo Clinic, Dr. Crutchfield personally treats all patients and states that experience counts and quality matters. Crutchfield Dermatology. Look good, feel great, with beautiful skin.
Welcome back. Access to Democracy returns. I'm Alan Miller, and we have a guest that we've had a lot of difficulty getting scheduled. Starting out when she was a new justice on the Minnesota Supreme Court, Justice Natalie Hudson, and I'm so glad we finally got you here and we finally be able to present you to our viewers who are not just restricted to this area anymore thanks to technology, but really as far away as I got a call from somebody in Germany about one of our programs that was watching it online. It just, so.
Well, thank you for having me, Alan. I am delighted to be here and delighted to finally get here, yes. Yes,
indeed. Now, you went on the court by appointment of the governor in 2015.
Correct.
You had to stand election this past year in 2016, which you won handily going away, even though you did have an opponent, which is unusual in Supreme Court races. And you come to the Supreme Court probably with more judicial experience than just about anybody who has ever been elected to the court that I have been able to trace back. So why don't you give us a little bit of background about how it started, where you started, and the progression to the court.
Well, thank you, Alan. Yes, I started my career at Southern Minnesota Regional Legal Services in 1982, and I did housing law for legal aid for several years.
These are for indigent people who can't afford counsel, right?
Correct. And I did housing law for 4 years there at Legal Aid. I left there and went to the Robbins Law Firm where I practiced employment law for a couple of years.
Mike Cerisi has been a frequent guest on our program.
Outstanding attorney and just a wonderful person as well. And I, after leaving the Robbins Law Firm, I was the Dean of Students at Hamline University School of Law, which then was just Hamline. And then
Professor David Schultz is a frequent guest of ours, political from Hamline.
Yes. And then I had the opportunity to become the St. Paul City Attorney. Mayor Scheibel appointed me, and I thoroughly enjoyed that position. And then I think what was one of the most formative positions for me, though, was when I left the city attorney's office and went to the Attorney General's office in 1994. And I was there for 8 years practicing primarily appellate law, criminal appellate law. And so I had the wonderful opportunity to write briefs and do oral arguments before the Court of Appeals and the Supreme Court, on which I would later sit. And so it was a wonderful opportunity for me. That is when I realized that this was my niche, that appellate law was my niche. This is what I love to do. And so I just thrived at the AG's office and doing that appellate work. And then in 2002, Governor Ventura appointed me to the Court of Appeals. And I served on the Court of Appeals.
It's amazing, because whatever we say about Governor Ventura, his judicial appointments were very well considered, thought out, and
I believe so.
Yeah.
But I think routinely people would say that of the governor. And the governor took the positions seriously. He took appointing judges seriously. He studied. He had a very strong judicial selection commission around him, which still exists. That commission still exists. And he utilized that commission to vet applicants for all of the courts, the district courts as well as the Court of Appeals and the Supreme Court. And so I had that, I was given that opportunity by Governor Ventura to sit on the Court of Appeals, and I was there for 13 years. And
which is really incredible before
is
you finally ascended to the Minnesota Supreme Court. But the fact that you had 13 years on the court is what I say probably made you as well prepared as anybody who's ever ascended to the Supreme Court.
In many ways, I think that's true, Alan. I don't think there's anyone on the current court, or probably prior courts, certainly that has written as many opinions as I have, when you combine that with the hundreds of opinions I wrote as a Court of Appeals judge. And so I brought that experience with me. And it's invaluable experience. Many of the issues we see now in the Supreme Court, I've had an opportunity to confront in my position, in my role as a Court of Appeals judge. And so yes, it was invaluable experience. That's not to say, however, that there hasn't been a learning curve, because I found my position on the Supreme Court to be challenging, and while there are a number of similarities, there are also a number of differences as well. But there's no question that appellate experience is something that sets me apart from my colleagues on the court, and that I was able to bring to the court, and I think is of benefit to the court.
Well, it has to be, to the court and to the state.
And to the state, absolutely. Absolutely.
And as you know, retired Justice Paul Anderson has been here many times, and is in large part responsible for forcing you on to this.
Oh, he didn't force me. No, I am happy to be here.
This appearance. Yes. And Justice Lillehag, Justice Strauss, and who have been here repeated times, among others.
Well, I think it speaks to, and I'm sure I speak for all my colleagues, you provide a wonderful opportunity for us to talk about the judicial system. I think the judicial branch is probably the least understood branch of the three branches of government. We're more invisible, I think, to most citizens, particularly the appellate courts. And you provide an opportunity for us to talk about what the courts do and their role in the citizens' lives, and how we differ from the other branches. And I think that's an important community service. And so I think it's also a testament to the show. And
I forgot. Mimi Wright was here also before she moved on to the federal courts. So many of them, and so many times. And Justice Strauss hasn't been back for a while, because while he was under consideration for the Supreme Court under this new administration, I think that it was not right to ask him to come on, but he's always been gracious about it also. And it really is something that we see as a service to the community in terms of this show, because it gives us the opportunity to humanize justices. And you know, they are just not people in black robes sitting up there making decisions. They are really flesh and blood individuals who have had their own lifetime experiences, and it's good for people to know that they are there and that they understand. And
absolutely. I think, you know, and I appreciate that, because we are human beings. We each bring to the court our life experiences, our professional experiences. We don't come to the court as blank slates. We've been written on, so to speak. And I think it's that combination of life experiences that adds to what we do as judges, what we bring in terms of our legal experience and our understanding of the law and our interpretation of the law. And so we come as human beings, and so you're absolutely right about that.
What people also don't understand necessarily is that divergent philosophies don't really permeate personal relationships on the court.
Absolutely.
We have people on the far right, we have people on the left, we have people in the middle, but the way that the court is structured and the way you justices handle it is a very friendly relationship, irrespective of your personal philosophies.
Absolutely, Alan, and that is so important. That collegiality of which you speak is so important in a collaborative body like the Supreme Court. We each bring our, as I said, our different personal views, our different legal backgrounds, but it is that diversity of legal backgrounds and experiences that makes for a richer and a deeper discussion when we're in conference and wrestling with these very complex issues. And it is very important that process and those discussions remain collegial, and they do. Of course, we're going to differ from time to time, but that is a healthy process.
Well,
that's a healthy part of the process.
Of the U.S. Supreme Court, the late Justice Scalia on one side and Justice Ginsburg on the other side. It's interesting, I went to the right with Scalia and my arms moved to the left with Ginsburg. And where their differences were even vitriolic at times in terms of judicial philosophy, and then they would leave and go to the opera together and were close friends. Right. The same with Justice Sotomayor, and she would go shooting with, with Justice Scalia.
It's a testament to you can differ philosophically about the law, but still respect one another, even like one another as individuals. And that is certainly true on our court. We have strong differences of opinion from time to time, but we respect one another, and most importantly, we respect the institution. And I think that's what drives many of our discussions and is the foundation for how we deliberate together and how we conduct business together, is a respect for the institution above all else. And it is in that way, because we do respect the institution, that we can best serve the people of Minnesota. And so sometimes, you do find strange, what some people might think are strange relationships or personal relationships, but that happens with some frequency, actually.
And with the method of selection which we have here and the history of this court, it has been really one of the most respected courts in the country for dozens of years, probably a generation or two generations.
I think that's right, and I am that's one of the reasons I'm so proud and honored to now be sitting on such an esteemed court. But I think, again, it's a testament to the fact that as a court and as a state, really, we have tried, but certainly the judges that now sit on the court, my colleagues, we have tried hard to protect the independence of the judiciary, to make sure that, as best we can, that partisan politics and do not infect the judiciary, because really all we have as a judiciary is the trust of the people. And if the citizens do not trust or cannot trust that we will be independent, nonpartisan, and weighing their cases and judging their cases based upon the law as opposed to our personal preferences, we lose a lot. And so that trust is key. And I think our court now and the many courts before us believed in that as well, that the independence of the judiciary is vital to our democracy.
Particularly in what we have is a very charged political atmosphere in the country right now. And I think courts were never more important than they are now. We have an unexpected president, really, based on the polls, and there's been a lot of volatility there. Some of the moves that he has instituted, like the current Muslim ban, has been contested. Well, it's gone to 4 or 5 district court justices, all of whom have said unanimously that he overstepped his bounds here constitutionally. So that's just one indication. Another is that the executive branch, and I'm speaking nationally now, and the legislative branch are held in such low esteem by the people, by the voters. I mean, we're talking about 15-20% acceptance rate. So we have to fall back on the judiciary. We have to be able to respect them and, hope that the decisions which flow are not political. The decisions are based on the law.
I couldn't agree more, Alan. I think, as you say, in this particular environment, it really just underscores the importance of an independent judiciary. One, as you say, that the people can have faith and trust in, so they know that when they walk in, whether it's a district court for a trial or whether they're in the appellate courts, they know that when they walk in that regardless of what's going on politically and which way the political winds might be blowing, that they're going to get a fair hearing, that they are in front of a judge or justices whose first allegiance is to the Constitution and the laws that have been promulgated by our respective legislative bodies. And so the more that we protect that, as you say, there has to be an institution that is above the fray.
Otherwise, we have chaos.
Otherwise,
and
we have
anarchy.
chaos. Otherwise, we have chaos. And I think our courts in Minnesota, all of our courts, from our trial courts to the Court of Appeals to the Supreme Court, evidence that we do have in Minnesota an independent judiciary, and it's something that is worth fighting for to maintain.
And what people don't necessarily understand is that the U.S. Supreme Court is the final say on a lot of things. But in Minnesota, we can take a different approach through our courts on certain very basic issues, and we could be more liberal or more conservative in some respects as the state, and that would hold unless it's a constitutional issue which gets to the U.S. Supreme Court. And that court hears maybe 80 cases a year, and they have maybe 2,500 or 3,000 petitions to hear cases. Very few make it.
That's right.
So
That's right.
So that makes the state court more important.
Yes.
Even.
Here in Minnesota, obviously, the Minnesota Supreme Court is the court of last resort. And so most cases, once they come to us, they end with us. Ironically, 80% of the cases in Minnesota actually end at the Court of Appeals because, like the U.S. Supreme Court, the Minnesota Supreme Court grants very few petitions, what we call petitions for review. We're taking primarily cases of statewide importance, or where the Court of Appeals has ruled on a constitutional issue, or where there's a need to develop or clarify or harmonize the law. And so the funnel narrows considerably in terms of what cases actually get to us. But those that do are there because they are of statewide importance, and they are critical to the citizens of Minnesota, and we are the last word. You alluded to one other aspect of our work, which is obviously we are bound by the U.S. Constitution, but there are instances in which the Minnesota Constitution can provide more protection for its citizens. We can never provide less than what the U.S. Constitution provides, but there are instances when we can and have provided more protection for our citizens. So But so yes, you're correct. We are the court of last resort, and the types of issues that we deal with, as I say, are typically issues of statewide importance. So it's not just that it's important to the individual parties that are in front of us, and of course it is important to them, but typically the cases that we're wrestling with are important to the citizens of Minnesota as a whole.
In 15 years on the bench, is there a type of case that has been the most difficult for you to really deal with, or pretty much with the background of statute and other cases, have you been able to take anything as it comes and not feel that it's more difficult than anything else?
Well, I think for many judges, and I would put myself in this category, dealing with the first-degree murder cases is difficult. The issues can be complex, but sometimes it's not so much just the issues, it's the tragedy of what has occurred. And the fact that although we don't have the death penalty here in Minnesota, that if you affirm that conviction, that you are essentially sentencing someone to life. And the weight of that is heavy, I found, because we don't deal with first-degree murder cases at the Court of Appeals. The Supreme Court has original jurisdiction, or what we call mandatory jurisdiction, of those cases. And so those always have a difficult aspect to them. And the other, we don't see as many family law cases. Our docket is primarily criminal. But sometimes the family law cases are difficult, again, just because of the emotion and what's often wrapped up into those cases.
I was going to ask you, and I have asked some of the other justices, if there's ever been a case that you've been involved in where your heart says, I should go this way, but the law says, I have to go the other way. And how you deal with that. I would find that in particular very difficult.
It is very difficult, but I think, and the answer is yes. I think all judges have had that happen. It comes with the job, and it is very difficult. But I think one of the oaths that you take when you say you want to be a judge and they put the robe on you is that you will uphold the Constitution. You will uphold the laws as you find them. And you have to become comfortable with that. I think there's probably not a judge or a justice out there that has not written an opinion that they did not personally agree with. And sometimes you just have to do that because you go where the law takes you. Sometimes there's room to do something else, but many times you have to go where the law takes you. And that, I think, is just simply a respect for the three branches of government, recognizing that many times in those instances, what the party wants from you is to change the law, and that's really for the legislature to do. And so it's very important that as a judge, you respect all three branches of government, and you respect the role that the judiciary plays, and that you not overstep those bounds. So yeah, it's difficult, but you learn to do it.
Now, family background-wise, your husband was a former police officer, I believe, who then became a pastor, went on to become the chaplain for the St. Paul Police.
Full circle.
Right.
Yes. Yes.
Interesting, because generally a police officer would have a different philosophy than some of the judges. Perhaps many of the judges. So that has to lead to some interesting dialogue. You have a son who is a practicing attorney, I think.
He's with the BCA. He's a criminal intelligence analyst with the BCA. So he's not practicing at the moment, but he did practice for many years.
I have to get in touch with him and ask him some questions for the novel.
You should. You absolutely should.
You'll have to give me a heads up on that one.
Yes.
Because I have many questions.
Okay.
But so that gives you, family-wise, a really interesting perspective.
It does. We've had, over the years, my husband and I and my son, we've had many interesting discussions about the law. We come at the law from different perspectives sometimes. But yes, they've been. It's been a fascinating experience. My whole family has been devoted to public service, and so we have an interesting perspective about all aspects of public service. Absolutely.
Now, do you read John Sanford novels?
I don't. No.
Because he is so involved with the BCA in his novels. I'm sure your
I'll have
son
to
would
look.
be.
I bet.
Just about everyone. And Sanford, of course, which is not his real name. I forget what that's his pen name, was a reporter for the Pioneer Press before he became an author. And it's very interesting. Everything's interwoven about Minnesota and about the BCA. And I've learned a lot from just reading his novels, among others.
Yes.
But
I'll have to look into that.
Yeah. And if you had to describe your judicial philosophy, what would it be?
Well, Alan, I think you start with the rule of law. And as judges, we're committed to that you take the law as you find it as a judge, and then you apply the law to the set of facts of the case that come before you. And that is the oath that we take, and I take that aspect of my job very seriously. I also believe, though, that I am an interpreter of the law, because sometimes the law is not clear. Most of the time it is, and so you apply the law as you find it. But there are times when the statute, for instance, that you're interpreting is not particularly well written, and it's not clear.
Legislators sometimes do that, more often than not, as a matter of fact.
And if robots could do what we do as judges, then you wouldn't need us. And that's where I think you bring your judgment, your background, your history, your legal experience, your personal experiences, where they come to bear as you interpret what's in front of you and interpret the arguments that the parties have presented to you.
Your passion for keeping this a civil society.
Absolutely.
Which is not easy at times.
No, it's not. And so I think, like I say, you start with the rule of law, and then when things get a little fuzzy, you bring to the table, your compassion, your reasoning, the lens through which you view, because of your personal background and experiences and professional experiences. So that it gives you a particular lens through which you view arguments and rationales. And you try to make the best decision that you can. I see, and various constitutional law scholars frequently talk about this, and I tend to agree with it. I see the law primarily as a shield and not so much as a sword. In other words, we are there to protect the rights of the citizens, in this case of the state of Minnesota, to make sure that the law applies to you just like it applies to the citizen down the street. And just like whether it doesn't matter how much money you have or you don't have, that the law is applied evenly. And so I see the law in my role as a protector of those rights, and to make sure that they're applied fairly and uniformly, regardless.
It's been a pleasure, really, meeting you and discussing this with you, and I hope this is the first of many visits to us. We've been talking with the Honorable Natalie Hudson of the Minnesota Supreme Court, and really, good luck and thank you.
Thank you, Alan. Thank you so much. It's a pleasure.